We will go on the record in the matter 25 CF 53, State of Wisconsin versus Laura Chamberlain. This date appears through District Attorney Kevin Schmidt in person. We have Ms. Chamberlain appearing in person in custody with counsel Renee Landgraf. We're set here today in this matter for a plea and sentencing hearing. The parties have reached an agreement. Ms. Landgraf, can you please recite it on the record?
Yes, my client will plead guilty to counts 1 and 3 by way of a deferred judgment of conviction. Amended count 1 to a class F felony, manufacture designer drugs less than 3 grams as party to a crime. And count 3, class I felony, maintaining a drug trafficking place party to a crime. Again, those are both subject to the deferred. And then she will be pleading to count 5, class I felony, possession of methamphetamine. And for that charge, we have a joint recommendation for judgment entered, sentence withheld, 3 years probation.
All righty.
Anything else will be dismissed and read in.
Sounds good. And I believe the basis for reaching this agreement was stated on the record at the last hearing. Lab actually determined that it was under 15 grams, so that went into the negotiations. Therefore, the end of the line agreement was less than 3 grams. Formal motion to amend.
So made.
Granted. Okay, plea questionnaire waiver of rights, I believe, was filed.
It's document 74.
Thank you. And I have the proposed deferred judgment of conviction. Do I have a signed one?
I think that is the signed one. It is. It's signed by all 3 of us.
Excellent. Okay. So, Ms. Chamberlain, you heard the agreement that's been stated on the record, correct?
Yes, ma'am.
And that is the agreement that you've reached with the state.
Yes, ma'am.
Did I ask you formal motion to amend count 1?
If not, I'll do it again.
Granted. Good. Okay. So I have the plea questionnaire waiver of rights form, and I have the proposed deferred judgment of conviction document in the electronic file. Ms. Chamberlain, did your attorney go over both of those documents with you thoroughly?
Yes, ma'am.
Did she essentially read them to you word for word?
Yes, ma'am.
And do you understand them completely?
Yes, ma'am.
If by chance there was something you didn't understand, did you ask her to explain it until you did?
Yes, ma'am.
Did you sign both of those documents?
Yes, ma'am.
So you were pleading guilty to 1 count of manufacturing, delivering a designer drug less than 3 grams as a party to a crime, a class F felony, and 1 count of manufacturing or maintaining a drug trafficking place as a party to a crime, a class I felony, and 1 count of possession of methamphetamine, an I felony, as a party to a crime. It says as a party to a crime. I don't know if that's what it's pleading to.
You should probably amend that to no party to a crime because that
was not his.
It was in her wallet.
From
That's
a motion
correct.
to remove party to a crime on possession of methamphetamine.
So made.
Granted. So you're pleading solely accepting that responsibility.
Yes, ma'am.
Now, you are 52 years old. You have a high school diploma and college. You can read, write, you understand the English language. Is that all correct?
Yes, ma'am.
And for the record, you are looking at an electronic version of your plea questionnaire, and you will have the deferred judgment of conviction to look at as well, correct?
Yes, ma'am.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt as it relates to all 3 of these?
Yes, ma'am.
Did your attorney go over with you the maximum possible penalties you face?
Yes, ma'am.
You are not receiving treatment for a mental illness or disorder. You've not had any drugs, alcohol of that nature, but you've had prescription medications. Is that correct?
Yes, ma'am.
Do your prescription medications interfere with your ability to comprehend or understand what's happening?
No, ma'am.
Because you're being charged with crimes, you are entitled to constitutional rights. Each of these rights is listed on the first page of both of those documents. You can see them right now. Now, did your attorney thoroughly go over those rights with you?
Yes, ma'am.
Did she explain them again to you very thoroughly so that you fully understand them?
Yes, ma'am.
And do you understand them?
Yes, ma'am.
Do you need me to go over those rights with you in any more detail?
No, ma'am.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes, ma'am.
You understand you're pleading guilty to a felony. As such, you will no longer be able to use or possess a firearm for life.
Yes, ma'am.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, ma'am.
Now, do you understand here, with regards to this case, the state would have to prove for count one, manufacturing a designer drug less than 3 grams as a party to a crime on or around March 20th, 2025 in Burnett County, Wisconsin, as a party to a crime you did unlawfully and feloniously manufacture dimethyltryptamine, DMT, in amount less than 3 grams. Do you understand what the state would have to prove?
Yes.
Do you understand what it means to be a party to a crime?
Yes.
That means, though, that either you directly committed the crime yourself, you aided and abetted someone who is committing the crime, you conspired with someone who is one or more people who were looking at committing a crime, and one or more steps were taken towards that commission of the crime. Do you understand what it means to be a party to a crime?
Yes, ma'am.
Do you understand that with regards to this matter and the amended count from a Class C to a Class F felony, that the maximum possible penalty could be a fine of up to $25,000 or 12 and a half years of incarceration, or both?
Yes, ma'am.
Do you also understand that with regards to count 3, maintaining a drug trafficking place as a party to a crime, the state would have to prove on or around March 20th, 2025 in Burnett County, Wisconsin, as a party to a crime, you knowingly maintained a building which is used for manufacturing controlled substances in violation of Wisconsin law. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 3.5 years, or both?
Yes, ma'am.
Do I need to go over what it means to be a party to a crime again?
No, ma'am.
As to count 5, possession of methamphetamine, the state would have to prove on or around March 20th, 2025 in Burnett County, Wisconsin, you possessed a substance. The substance was a controlled substance, methamphetamine, and you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes, ma'am.
You understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration, or both?
Yes, ma'am.
You also understand that there is an agreement that's been recited on the record, and that would include a deferred judgment of conviction document. Do you understand that I'm not bound to follow either the deferred judgment of conviction or any recommendation for sentencing?
Yes, ma'am.
I can sentence you all the way up to the maximum penalties if I thought it was warranted. Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter guilty pleas?
Yes, ma'am.
Now, did your attorney thoroughly go over the terms of a deferred judgment of conviction
Yes, ma'am.
and the requirements that you would need to make in order to have this deferred judgment of conviction be successfully completed?
Yes, ma'am.
Now, did your attorney also go over with you the facts alleged in this case, which would be in the probable cause section of the criminal complaint?
Yes, ma'am.
Now, I'm not going to have you say that every fact is accurate, but for the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did manufacture a designer drug here known as DMT?
Yes.
Are you admitting here today you in fact did maintain a drug trafficking place,
Yes.
both as parties to a crime? Are you admitting here today that you in fact did possess methamphetamine?
Yes.
Are you pleading guilty to each of these counts because you are guilty of these offenses?
Yes.
Ms. Landgraf, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No, Your Honor.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing,
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has she answered all of your questions?
Yes.
Has she looked at this matter thoroughly?
Yes.
Has she looked at the discovery and the evidence and discussed it with you?
Yes.
Has she discussed and talked to you about any potential legal defenses you could have or a lack of defenses?
Yes.
Did she discuss with you that it is your right and yours alone to decide whether or not you go to trial?
Yes.
Is it your decision to enter guilty pleas here today?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
Are you satisfied with her services?
Yes.
Ms. Landgraf, do you believe that your client is freely, voluntarily, knowingly, and intelligently entering pleas today?
Yes, Your Honor.
Do you believe she fully understands the elements of the crimes as well as the facts that would support each of those elements?
Yes, Your Honor.
Do you believe she understands the maximum possible penalties that she faces and that it's the court's discretion as to sentencing?
Yes, Your Honor.
Do you believe she understands the rights she is giving up here today?
Yes, Your Honor.
Do you believe she is fully competent to enter her pleas?
Yes, Your Honor.
As to count 1, manufacturing and delivering designer drugs less than 3 grams, a class F felony as a party to a crime, how do you wish to plead?
Guilty.
As to count 3, maintaining a drug trafficking place, an I felony as a party to a crime, how do you wish to plead?
Guilty.
As to count 5, possession of methamphetamine, an I felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of all 3 offenses. A judgment of conviction will be entered as to possession of methamphetamine. I will hear arguments as to all right now. The remaining counts are dismissed and read in for purposes of sentencing. Mr. Schmidt.
I'd ask the court to follow the plea agreement today. The basis for the agreement is 1, Ms. Chamberlain has no criminal history. She got to middle age when this all happened. There were a number of drugs found in the building and she had methamphetamine on her. But the main concern we had when doing this case was the dimethyltryptamine in the dimethyltryptamine lab. The reason why the charges are much lower than what we originally charged is because, as the court recalls at the prelim, we don't really have a good way of saying how much dimethyltryptamine was actually produced, given the state it was in at that time. When I was preparing witnesses, talking to our expert from DCI, as well as the lab people, they could not give me a number or extrapolate based on those mason jars they found how much was actually made. Those mason jars are what are the end result of creating dimethyltryptamine, where basically you keep taking layers off the top and freezing and it becomes dimethyltryptamine. The other reason why the agreement became what it was is through talking with my experts and learning, dimethyltryptamine is significantly less dangerous than I thought at the beginning of this, and so was the lab. So dimethyltryptamine, despite the name, is actually a naturally occurring chemical in nature. It is from plants from South America. It's actually legal in quite a few countries in South America. It's not addictive. It causes sort of like LSD-like trips that last about 15 minutes. You can't really overdose on it very easily. You'd have to combine it with something else to actually overdose. It doesn't cause addiction. It's not habit forming. And in fact, there's actually a Supreme Court of the United States case about dimethyltryptamine in Gonzalez v. O Centro Espiriete Beneficiente União do Vegetal.
We're going to need that.
I can give the spelling to the clerk at the end, or the reporter at the end. That's 546 US 418 2006. The Supreme Court of the United States actually held that dimethyltryptamine, the dangerousness of it is not enough that the government can have a compelling interest to bar the use of it religiously. It is used by certain churches from South America in taking sacrament, as well as many traditional tribal uses in South America. Discovering all that about dimethyltryptamine, I had thought it was maybe more of it's in the designer drug statute for Wisconsin, so I thought it was closer to methamphetamine. It's less dangerous than methamphetamine. And the lab itself was also not super dangerous. The reason why the clear team, the clandestine team, went in with so much gear is there were some chemicals there that could have been used to create a substance called ricin, which is a Cold War era like poison. When they got in there and looked more closely, they determined this is not a ricin lab. They took off the PPE, and dimethyltryptamine labs, especially this one with how they created it, didn't have a danger of like explosions or contamination or something like that. The most dangerous thing about this lab would be the basic substance in the mason jars that is used to purify the dimethyltryptamine. So taking those things together, this shouldn't have a sentence like, say, somebody who had a methamphetamine producing lab. That is very dangerous to do. Those labs can explode. They do lots of contamination that can last for a very long time. And this is different than that. So that's why in this case, we did this much lower amount, because I don't know how the jury would find a specific amount in this. We did give a weight for one, I think 2 pulls off of 2 of the jars, but does that really tell you how much was manufactured, or does it tell you how much was in the jar with the basic substance that purifies the dimethyltryptamine? Can't really say. We didn't find any of the actual completed dimethyltryptamine. When it's produced this process, you'd find it would look like some sort of crystal is how it would kind of look, and we didn't find that. We didn't find the sheets that you would probably put it on and put it in a freezer to do that last step. So taking all those things together, all this information, as well as her lack of criminal history, I think she's already sat a very long period of time in custody. She has no criminal history, so that's going to be a pretty significant deterrent to her. She's not going to have access to the building where this happened again, because ownership of this already changed through function of the Polk County Court. And I do think the probation on the methamphetamine is important, because, like I said, if somebody is the age Laura Chamberlain is when they suddenly break bad, then we still have a chance to bring them back to where they were before that. And I think that probation is the best way to do that. Thank you.
Thank you. All right, Ms. Landgraf. First, you have jail credit.
I do. Just had it pulled up here. 344 days, including today. So that's 11 months and 7 days.
All right, so 343. Okay. Ms. Landgraf.
I just want to make sure that the court received my sentencing memorandum. It's
I
document
did, I
77.
read it. It's all good.
Okay, perfect. So, not to rehash all of that, I agree with everything that the district attorney said. In fact, I learned some stuff just now. But I think we do have a weight. I mean, there was 3 different weights given in the crime lab report. So I think the jury could find that there was 14.618 grams altogether. I don't know what was all sent there, but that's what was sent. All of the ingredients to DMT can easily be found online. Ms. Chamberlain admits that she and Mr. Chafee were experimenting with that, despite the law enforcement seizing all of these cell phones and other evidence that was testified to at the preliminary hearing. There's absolutely zero evidence that there was any indication that they were going to sell this or deliver it to anybody. My client states that they were solely just experimenting with it for their own personal use, although I don't think she actually knew that they got to the end point where the DMT was actually manufactured, because they didn't actually consume any of it. But again, she has no criminal history. And I believe her mom is her biggest support system, and is going to help get through this process after she's released today, because she has been incarcerated for a very long time and she's never been arrested or in jail before. So this is an extremely life-changing event for her. And unfortunately, she's a convicted felon after today. I did discuss with her the pardon process, and hopefully she will be able to do that someday.
Okay, thank you. Ms. Chamberlain, anything you want me to know about you, about your past, about where you got to where you are here today, and anything you think about your future?
Thank you, Your Honor, for allowing me a moment to speak.
If you are going to read something,
Yeah.
please read it slowly and enunciate your words. My court reporter needs to take everything down, and I just need to make sure that I can understand it.
Mhm. I'd like to let you know that I have used my time in here to reflect on my situation. I'm grateful.
Judge, I want to make sure that you got the 2 character letters that were submitted as well.
I did, I read those too.
Okay, thank you. Sorry.
I am grateful that through the support provided to us here, church, Bible study, women's support group, AA, NA, and parenting class, of which I've attended, every time that they're here. I have learned many things about myself that I had lost or forgotten. I'm a strong, forgiving, loving woman. I have peace in my heart that I haven't in a long time. I found myself again. I plan on getting a job, a place to live, and to contribute in a positive way to my community. I believe I'll be able to do this through the support of my family, friends, and support groups available to me. I have faith in the decision that you make being the best in my interest, in my best interest. Thank you.
Thank you. Well, I don't just have to look at you and make sure that your rights are protected and all of those things. I also have to look at the public interest and what's in the best interest of the community. I appreciate your statement, Ms. Chamberlain. I read Ms. Landgraf's sentencing memorandum. And I'm just going to start with that. I read it. I was shocked. I mean, who is sitting in that chair right there in orange as to who I have in black and white right here? Unbelievably, completely different. Two completely different people. And I don't know what led you or brought you to that chair. I do have an idea because of this case, I had to get to know your divorce and what happened there. I got to know that, and through this, you were married 30 years or almost 30 years. You have two grown, apparently wonderful children. And you are a grandparent, and it sounds like, and what I'm able to gather, I can read between lines too. You had a really good marriage. You did a lot of great things, ups and downs, I'm sure. Marriage is ups and downs. But together, you were a great team because you built great, wonderful things. You were a businesswoman. I don't know the level of college you had, but I can tell you, seeing you there and knowing what conduct you have done to get you here, and then knowing where you were before, I'm going to tell you, you are a smart woman. You are a smart woman who has done stupid things. And I believe it has something to do with your heart. I'm not discouraging you. I can't tell you who to love and who not to love and who to get into relationships with. But you seem to have had a great life, doing great things, being a very strong, independent woman who can accomplish so much. I didn't know you did that. You and your husband built that winery. It's amazing. But for the fact of probably the divorce and that downfall, you most likely, and getting in and going the opposite way, and you most likely probably would have built the building in Grantsburg into a thriving business. I don't know what led you down the road to substances. I have ideas, but it makes me sad as a person and as a judge to see somebody who was thriving so well in life and doing well and hit a huge rough patch. There's a rough patch there. Because in reading the things that I had to with your divorce, whatever happened in your marriage and how you happiness, not happiness, fights, not happiness. The divorce was tumultuous.
It was brutal.
That's what I gathered. And so it's really hard, I'm sure. It's like a death. And it affected you, it affected your children. Don't let it destroy you. And I know it's hard to see, and for a person that you looked in their eyes and you said, I do forever, and you loved him immensely, to go from that to where you were in your divorce, I can see that pain. And that is trauma. Absolutely no excuse, no reason to fall into substances, absolutely no reason to start to build a lab, for substances. I'm going to tell you, I never paid attention or heard of dimethyltryptamine until this case. But I'm going to tell you, once I heard dimethyltryptamine, DMT, I now hear it in shows, and I hear, and I said DMT. I'm sure I've heard it before, but it never clicked because I've never had to know what it was before. I'm glad to learn about it. I knew about it to the extent of it's all legal things you can buy on the internet. You can do those things, but it's once you start to manufacture it and bubble it and then make it into the crystals, that's where it's illegal, because it's a substance. It's an illegal substance and it's a lab. I can see that this has had a significant impact on you and your whole life. I believe Ms. Landgraf stated you are going to start anew. You have to start fresh now. You don't have
I don't have
clothing, you
anything.
don't have furniture, you don't have anything because you were arrested from that building. You were brought here. It's been 344 days. And now you're a convicted felon. Again, that pains me as a person and as a judge to know that somebody who did such great things in her life got to this place. And I'm hoping, and I think it's going to happen, that because you've had your epiphany in custody, you've had your time to become sober and have the substances, all of them work their way out of your system. I'm confident that you are going to have even more epiphanies. You are going to grow and you are going to become somebody else who can do what's written in the black and white from the memorandum versus the black and white of the criminal complaint. I'm just going to say, no man, no love, no anything is worth your self-respect, your criminal record, your life.
I made the choices. They were my choices. And I just didn't want to feel.
I understand that. I get that.
And I know that it was wrong.
You are owning that. I understand that and I get that. It's just hard for me to read who Laura Michelle Chamberlain was and to think that she would have made those choices even with the impact that her life was having, but for other factors. And I understand the heart, I truly do. But I also understand strong, independent women and those that need to continue to rebuild and look out for themselves. Because it's your life, it's your children, it's your grandchildren. I don't think that the communities would be hurt or at risk if I put you on probation. You have no criminal history. Again, this was the worst, most terrible time in your life and you made the worst, most terrible choices. So what I am going to do is I will adopt that deferred judgment of conviction. That'll be in place and you must do all of those things. I'm going to tell you the number one reason I see the state asking to terminate and revoke that agreement is, and to have me sentence on those felonies, is the payment of $150 within 60 days. Get that done.
Yep.
Get it done immediately. Do your AODA assessment and make sure, even if you have to hand walk the documents to the district attorney's office, that they have that documentation. Because I don't want to see those little things. They're not little, but they're little compared to other factors. Those things be the reason why you face going to prison. With regards to the possession of methamphetamine, I will follow the recommendation, 3 years of probation. Generally, I would think, and I have in other cases, that 3 years, that's a lot of time to be put on probation for your first criminal offense. But this is a doozy. This is your first criminal offense and they're felonies. And you obviously need some help. And it's not, it's unfortunate that it has to be in a way that the Department of Corrections will be watching over you and the state will be watching over you. But I want you to get back to who you were. Again, before this memorandum, I would never have guessed, just knowing the black and white of the criminal complaint, okay? You deserve to be back to Laura that you were meant to be, that your family deserves you to be. And they want you to be. So 3 years of probation. I'm not going to do a withheld sentence because I'm going to tell you if she's going to be revoked, she's going to be revoked. And then she's going to be sentenced on the other matters too. Because, well, I'm second guessing that. No, I will do a withheld sentence. Because if you are going to be held and it's looking at being revoked, then you will be in custody and it's not going to matter because I'm going to have to hear arguments for 3 serious felonies. And quite honestly, I'm not prejudging or pre-saying anything I'll do, but all same date, same time, same place, same things. So I can't see why there would be, at least in my mind right now, consecutive sentences. Conditions of probation. Absolute sobriety, that AODA assessment and the follow through, a mental health assessment and follow through. You need to work through some of that trauma. Regular testing. No alcohol, because that's absolute sobriety. Gainful employment. And I am going to add 20 hours of community service. Done good for your community. And from all respects, I would think that you were respected from the community. And perhaps this could be something that has let them down. So just give back a little bit. So 20 hours. I don't think that's too much. I think you can do 20 hours in the first year. All right. 343 days of jail credit.
Judge, I think she gets credit for today because she's not going to be,
I can pull up the case.
oh,
Court of
okay.
Appeals case says you do not count date of sentencing.
Oh, okay. I thought that was only if like you're continued to be in incarceration because the DOC counts that.
I don't believe so. I don't know. If you want to show me, that's fine. Otherwise, if she's revoked, I'm going to tell you, DOC is going to tell me I need to add days or minus days or
Right.
all of those things. So you have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. The jail make sure that they have that. At least with the methamphetamine, you have the ability to request it be expunged through a written letter to the Department of Justice. With the other two hanging out there, they kind of have to wait to see. $518 in fines and fees for the possession of methamphetamine. I can't recall if it was asked or stated that she does better with her mom and to live with her mom. Was that even a request?
I can't live with my mom. She
Okay.
won't let me.
What's your plan?
Well, I will stay at my mom's for a little bit, but once I have a vehicle to find a job, find a place to live.
Okay, all right. Well, I will say that the $518, I'm just gonna say DOC can collect that. We'll worry about that later. I think that covers everything. Oh, if the deferred judgment of conviction gets entered, okay, not right. Oh, yes, no, you have been a possession of methamphetamine. Again, let you know, no voting until your civil rights are restored. No longer able to use or possess a firearm for life. So Hopefully you weren't a hunter. Mr. Schmidt, what am I missing?
Katie's crossbow.
Nothing from me.
Ms. Landgraf?
I've already went over her post-conviction rights with her, so I don't think that there's anything else.
All right, well, good luck, Ms. Chamberlain. You must report to probation immediately when you are released from custody. I need an address. Do you know your mother's address right now?
2057 244th Street, St. Croix Falls.
So you report to Burnett probation, they'll transfer it to Polk. Do you have a telephone number?
No,
You need to get a new phone?
yes,
Okay, and once you have a new telephone number, update the clerk's office as well as probation. If you move from your mother's address, not only do you have to update probation, you have to update the clerk's office here, okay?
yes.
All right. Nothing further than we are adjourned.
Judge, actually, one thing, her phone was compensated by law enforcement, but there was never a search warrant done. There was never a forfeiture filed to keep that phone. So I believe that it should be released to her. I just want to make sure that
That's
she-
fine.
that she can get her phone.
I have to order it on the record all the time with every sentence.
That's fine.
Okay,
With every
Mr.
conviction
That's a
order.
Mr. Schmidt question. He can release it.
Have her go to the sheriff's office and ask for it. They'll send something to me and I'll say, do it, and then she can set the time to pick it up.
Thank you.
All right, then we are adjourned. Thank you, Mr. Oyot.